as set out in Article 146, will be the reason for doing so. And especially, such reasons must affect public sensitive national interest or public order safety. I realize that in my case, should the public be made aware of the allegations in the petition, they would realize that none of the allegations made border even remotely on matters of national interest or matters of public order or anything that indicates that I'm unable to perform the functions of my office. An example is an allegation that I failed to retire accountable interest of $14,000 when I traveled. When I did retire that accountable interest 2 days after I returned from my journey, I was given $14,000. I could only spend $4,400, and I returned $9,600 2 days after I returned from Ghana, from my journey. And so I knew that it was necessary that the issues being thrown around as petitions against me needed to get into the public space. I swore to a supplementary affidavit alerting the Supreme Court also of human rights violations that I had started encountering when I went to the Article 146 hearings. However, the members of the Supreme Court that heard the application refused my application for the hearing in open, and they also struck out the supplementary affidavit at the request of the Attorney General.
that the former Leonard Chief Justice is pursuing now in court regarding her removal as a Justice of the Supreme Court?
Hey, Johnny.
Yes, sir.
You are pushing me into trouble. You want me to tell you the merit before the courts do? Okay. So, but for purposes of education, I would be as cautious as possible because this is sub judice.
We are grateful.
It's a matter that is before the court, and before the court decides, it is not proper for us to preempt their decisions by telling the merit of the matter. But what I can say is that there's a need. There's a need for the Supreme Court, which is the court with jurisdiction to interpret our Constitution, to actually tell us what it means for a Chief Justice to be removed, whether the removal will affect her status as a Supreme Court judge or as a judge of the Superior Court, or is just a removal from the office as a Chief Justice. That is not clear from the Constitution. And I believe that where it has started, there would be the need at a point or at a stage of the proceedings where it would be necessary for the High Court to refer that matter to the Supreme Court for interpretation, so that it will be clear. But for now, I will reserve my comments on the merits or otherwise of the case, Mr. Santipat.
There are those who hold the view that the learned former Chief Justice is overstretching this matter because really it's ended. So why this process? What do you say to that?
Well, she has a right to exercise. Whether the exercise of that right overstretches something or not, the question would be whether the overstretching, in any person's opinion, is also an infringement of another right. That is the only limitation that we can put on the exercise of another right. But as long as she has a right to approach the court for a relief or for a redress,
right?
I think she has that right, and whether the courts will grant her relief based on the law and the facts is another thing. But well, it's an opinion of the people who have it, and they also have the right to have that opinion that it's been overstretched. But at the end of the day, we will have a conclusion that will be clearer for all Ghanaians.
Let's go, Council. I'll have you hold on so we connect with Council Austin Braco Powers. Good morning, Council.
Good morning. Can you hear me?
I can hear you. You're loud and clear. You're a private legal practitioner as well. Now, we know that you have put out a petition. What is the terms, or what are the terms of the petition? Can you share with us briefly?
No, it's just an RTR request, right to information request.
Right. And what are you seeking?
It's patently clear. Per the decision of the Supreme Court, the moment the committee, the Article 146 committee, concludes its proceedings and submits its report to the presidency, that cloak of secrecy or confidentiality, is shed off. The cloak of secrecy and confidentiality is shed off by reason of the fact that the committee has concluded its activities. So the Supreme Court made it abundantly clear that the minute that these two incidents, so there are two incidents by which reason the cloak of confidentiality is shed off. One is where the presidency decides not to establish a prima facie case, by reason of which there won't be the formation of a committee. And two, if a committee is formed after the president having established a prima facie case, then in that instance, the only time the cloak of secrecy will be broken will be when the committee concludes its proceedings and submits its report to the president. So that the last part has been done. The committee has submitted its report to the presidency, the basis on which the Chief Justice was removed. On that score, I have filed an RTI request to the presidency to furnish my good self with the reports forming the basis of the Chief Justice dismissal. And I've also requested 6 other documents. I've also requested the report or the prima facie document, the report on the basis of which the president established the prima facie case. I've also requested the petition itself, the Daniel Foley petition, which granted the removal of the Chief Justice, and also the minutes of the proceedings of the Article 146 committee. These are the documents I've asked the president to furnish my good self based on the RTI request.
Are these documents supposed to be naturally in the public domain?
So I explained that the Supreme Court in the Justice Utageri held that the cloak of secrecy, when you look at Article 146, it says when the committee is established, or even the minute a petition is filed, from that word go, the petition must not be linked to the public. The proceedings of the committee must not be linked to the public. In fact, the term used by the Constitution is in-camera proceedings.
That's right.
It means that it should not be open to the public. But in the same decision, the court said the moment the committee concludes its proceedings and submits its report to the president, that cloak of confidentiality, the in-camera-ness with regards to the proceeding of the committee is broken. By reason of this, the report of the committee and any other allied document now fall within the public domain, something the public must know. Then it falls on the presidency to take the document, the necessary document to the public. Let the public now know the basis upon which the Chief Justice was dismissed, or the documents which granted the removal. These documents no longer should be kept secret. They should now be given to the public to consume. And that's exactly what that is the provision I am invoking before the president.
Now, Councillor Osman Alassan, what is your own view on this RTI information that Mr. Braco Powers is looking for?
Okay. That's another right to exercise, but I will focus on the request of the application that he has outlined. I'll take each one. Now, he wants a report from the president. I believe the application is directed to the president.
That's correct.
Okay. So he said he wants the report from the committee. Now, the first thing I will comment on is, you see, if you look at the Constitution, Article 146 properly, the committee is not supposed to submit any report to the president. They are supposed to recommend to the president for the removal of the Chief Justice. Whether that recommendation would include the grounds for the recommendation or the report is not clear. And so the question is whether the president actually has the things this person is asking him to give. Because what is clear in the Constitution is a recommendation. If he wants that recommendation is actually public. That recommendation can be furnished.
Right.
Now, he talks about the prima facie. He said the ground for I don't know whether the prima facie determination is based on the petition that was filed. So I don't get it when they say they want the basis for the prima facie determination, because the basis for the prima facie determination, according to the Constitution, should be on the facts alleged on the petitions. The question is, are they looking for the petitions and the facts based on which the removal is requested, or they want something else? because the decision of the president is not like a judicial decision that is written like court, which they say, okay, bring us your judgment. So let's look at it, you know. So that one is also something we have to consider, whether what they actually want from the president is something the president has to give. I think he also mentioned about the proceedings of the committee.
That's right.
You see, the proceedings of the committee are the proceedings of the committee. The president was not the one who conducted the proceedings. Now the question is whether after the work of the committee, the committee still exists to provide the proceedings. Now, if it exists to provide the proceedings, why is the petition not directed to the committee? Now, the question is, as soon as the committee finishes its work,
right,
it is still in existence. And if it's not in existence, where do we get their proceedings? Now, I think these are the matters, and I'm saying all these things because you need to know where what you want is. You might have a right, you might have a case, but you might direct it to the wrong forum. And if you direct it to the wrong forum, no one can give what he doesn't have.
I hear you.
And so, yes, so those are my comments on the application under the RTI.
Very well. Councillor Braco Powers, so what if the presidency or the president decides not to oblige? What will be the next step for you?
So the Right to Information Act is patently clear on this, that the minute an RTI request is filed with any institution, the institution has within 14 days to respond. And if there's no communication after 14 days, then you have to, the applicant, you have to file for a review, within which they also have 14 days. Then when that is done, you redirect your petition to the RTI Commission, after which you can then invoke your rights under the Constitution by going to the High Court. So there's a string of process, and it is clear that you cannot sidestep this process before going to the High Court. So, I mean, we are bidding our time. We are hoping to hear from them. We submitted the RTI request on the 10th of September, so they have within 14 days. So plus or minus, we are looking at if we are to calculate it based on the working days, then we are looking somewhere close to the end of the month to invoke the next step. But we are resolute to make sure that the minute the period elapses, we will take the next step.
I see. And the next step will be what? To head to court?
No. So, like I intimated earlier, the RTI Act, has an elaborate provision.
That's correct.
When you look at this Act 989, it has an elaborate provision on the process or the procedure, and it is a fundamental principle in law that where an act provides a means by which you should exercise your right, you must exercise it by that very means and not to sidestep it. Even though we can decide to go to court. But that should not be of need immediately because of the process or the procedure in the act. We need to exhaust the act so that when you go to court, you have a foundation. You can tell the court that you've already exhausted the procedure provided in Act 989. Other than that, why are you in court? When there's a procedure, you have not exhausted the procedure. What are you going to do in court? So you will need a foundation for the court to also protect your rights. But if you don't do that, the court will definitely not protect your rights. So we are ready to exhaust the procedure in Act 989 to make sure that at least we get access to these materials. And it is important to put across that the act of the committee, if the committee is established and it concludes its work, it becomes functioning official. It means that Yeah, it is done with its work.
That's right.
Then, if it is done with its work, why is the committee keeping its proceedings or documents or keeping its report?
I see.
You have to send it to the presidency for it to be kept at appropriate offices. So the committee no longer exists. If the committee is done with its work, why is there? So I mean, by that, would you say there's a committee in existence when the committee is done?
But given the dictates of Article 146, which also suggests that, or if you like, commands that all these processes should be in camera. Would it be appropriate if these documents get into the public domain?
No, but the thing is, why is anybody scared to release the materials to the public? The public must know. The public has the right to know. The public must know. So why you? The thing is, the reason why the constitution provided for the in-camera is to protect the sanctity. Particularly, don't forget, one of the fundamental principle in law is that you are innocent until proven guilty.
That's correct.
So, and it is the in-camera proceeding is provided to protect the sanctity of the judiciary, so to protect it from being pillaged in the beginning, in the initial stage. But when the committee concludes its activities and decides that it will be removed or not, or otherwise, then they are done with their work. Then there's no need to protect or guard any material or any document from the public, because after all, if the dismissal comes, the public will know. So any such recommendation and then after the report, the recommendation of the committee is in the report. The committee will provide reasons or justification for their recommendation. There's no way the committee will write maybe a one-page document or a two-page document and say, Mr. President, I want you to do A, B, C, D without justifying. Do you understand? There's no way the committee. So it is a report. When the Constitution says recommendation, the Constitution is not saying. Because when you read the report of the Committee of Experts, that proposed the 1992 Constitution,
right?
You know about. You find it clear that it is the recommendation of the committee is in a report. It is not a one-page document to the presidency detailing the recommendation that, Mr. President, after our work, we are recommending one A, B, C, D, without providing justification, without providing grounds, the basis of which the committee is making that recommendation. So the argument that it's a mere recommendation and that if you need, I don't think it's really a sound argument, because there's no way the committee will just file a one-page or two-page document to the president only with the recommendation. No, they must provide cogent and justifiable reasons for doing that, and they must ground their recommendation based on the fact alluded or the allegations as contained in the petition. So clearly, it's a report, and the recommendation is contained in it. So it is not a disjointed document that the president may not have or may not be willing to do. So I think it is. We have done what is right. So exercise the rights as provided in the Constitution and Article 21 also under Section 1 of the Right to Information Act 989. We are just giving the president the 14 days. We have nothing to do until the 14 days elapsed. We can then exercise our next step.
My final question to you on this matter is that what do you say to those who suggest that what you are doing is politically motivated and that you are doing the bidding of some politicians?
No, but sometimes that's one thing about this country. Because when people are genuinely acting out their rights, they just tend to see everything from the prism of politics. But must that be the case? This country has not made significant progress because of this needless partisan politics and politicking. The thing is, brother, we all have rights, which must be protected and exercised. If you don't exercise them, if you don't exercise the right, or if you exercise the right and someone says or claims that you are just doing the bidding of a political party, must that stop you? That is a person's perception. Perception must not necessarily translate into reality. If there's a right to be exercised, you must exercise it without fear or favor. So I I think it's a needless argument, and it will be petty, too petty for someone to say that they are trying to do a political party's bidding. Which political party bidding? But do we exist for a political party? We exist as citizens. We exist as Ghanaians. We don't exist for a political party. We existed before political parties were even established or even formed. So we still exist. When CPP was CPP not a formidable political party? Now where is CPP? Now where is the other political parties that were formed? So we are not here to do the bidding of political parties. We are here to do the bidding of the Constitution. We when you read the preamble to the Constitution, we the people. It is not they the political parties. Say we the people of Ghana. So we are exercising our rights as people of Ghana, not as political parties or assigns of political parties or agents of political parties. So I think it's a needless argument for anybody to make. All right.
Council Osman, Alassane, let me wrap up this conversation with you. The Chief Justice is headed to court in the public domain. For example, lawyer Kofi Bentel said a while ago that there's no merit in this matter and that the denting of her image is not a subject of law, a while ago on TV3. I know you will not take the temptation to get in there, but what will be your closing thoughts?
The question again, please.
I'm asking for your closing thoughts as we wrap up.
Well, my closing thoughts are that once this matter is in court, I am hoping that at the end of the day, there will be clarity on some of the gray areas within the Constitution. What I don't want to do is what my colleague on the other side, or the petitioner under the RTI, is saying, because he's made a lot of assumptions not based on law. You see, the Constitution makes it clear on what should be done. And you see, if you want to say anything which is not strictly a provision of the Constitution, then you need an interpretation of it from the Supreme Court. You cannot proceed on your own assumption or interpretation to do things and now and expect everybody to understand. So for me, I think the clarity should be from the courts, and we hope to get that from the courts, even if it means from the Supreme Court.
Thank you very much, Council. Bracco Powers and Osman Alassane, we're grateful for your time this morning. Okay, Helen. Egalise.
Egalise be brave.
It go be.
They concluded if they feel just that they have enough evidence to justify her removal. Why not? They have to present that report, and especially the effect of recommendation for removal is automatic. Yes, now, but you see, that's why I say it is the politics that has harmed this country very gravely. Why should somebody have that mindset? Somebody has been removed, therefore one will come with mass, irrespective of the merits.
Yes, they said that the NDC says before coming to power that they were going to reset the judiciary.
Yes.
And so this is politically motivated rather than, a case of...
Let us be a bit serious here. Look, when the parties are contesting for elections, don't they have their manifestos as to what they will come and do when elected into power? So when they are elected and they are implementing the manifesto, what's wrong with it? That is premeditated and it's endorsed by the voters, and they are implementing it. You mean somebody should just come to power without, any program for running the country? The important question is not when. I remember before the elections, I used to say here that the judiciary needed restructuring. They said NDC
lawyers, yeah.
That when he comes, of course, they will state it politically. Now he's also going to bring NDC. These things don't help us. And I remember I commented that so long as the public had lost interest in the judiciary, he had to do something to rectify it. But he cannot say, he should have said he will bring those NDC lawyers who are competent and objective-minded, and not just NDC lawyers. I said that. Yes. So you see something wrong. You are not in power, and you are not allowed to say that this is not correct. It has to be rectified. And when you say it and you come and you are pursuing it, then it is nonsense. This type of thing, is it commendable? That means they'll do it irrespective of the performance of the next Chief Justice. That's the mindset of some of these politicians. Don't you see it?
Okay. That's a retired Justice of the Supreme Court, Voice of Justice William Atuguba. We'll take a break here. We'll return from this break. We'll take you to the Ashanti region where the Dottier final funeral rites of the Queen Mother of the Ashanti Kingdom, Nana Konedu Boakye, Konedu Yadom, sorry about that, Nana Konedu Yadom, it's being held. We have a crack team there, and we will get you through to feel what's happening in